Welcome to Lecture 17, Privacy at Work. Understanding privacy rights in the workplace is a complex undertaking, primarily because there is such a patchwork quilt of federal and state laws that potentially may be applicable. In addition, the legal rules and principles differ greatly between the public sector and the private sector. In reality, there are only minimal privacy protections extended to employees. Constitutional protections under the Fourth Amendment against unreasonable searches apply only to public sector employees, and many of the federal statutes addressing privacy issues contain provisions which expressly or through court interpretation are inapplicable to a work environment. For example, the Federal Wiretap Act, which applies to private parties and generally prohibits the interception of communications, has limited application in the employment context due to several statutory exceptions. First, the law does not apply when one party to a conversation consents. Second, providers of the communication services are exempted. And third, the law does not apply when an interception occurs in the ordinary course of business. Most employers fall within one or more of these exceptions. Several other privacy laws, such as the Stored Communications Act and the Pen Register Act, also have limited application in the private workplace. There is also generally no objective expectation of privacy in the workplace, whether in the public or private sector. This is not only because of the inherent public nature of the workplace environment itself, but also because most employer handbooks or policies expressly state that employees have no expectation of privacy while at work or while using any employer-owned equipment or resources. In addition, most employee policies contain express provisions where employees, as a condition of employment, consent to various employer practices that otherwise would run afoul of privacy principles. As a consequence, employer monitoring, surveillance, and testing of employees in the workplace is widespread. Such activities are constrained principally only by what the employer agrees not to do in an employee handbook or contract of employment, or where a specific statute limits those activities. Of course, there are many sound policy reasons why an employer may wish to monitor or test employees while at work, such as maximizing productivity, preventing employee misconduct, protecting trade secrets or other company property, and reducing vicarious liability for employee misconduct. The limited privacy rights of private sector employees are principally enforced through 1. Breach of contract actions where the employers violate their terms of employment, 2. Assertion of common law invasion of privacy torts where employer conduct is particularly egregious, such as where an employer secretly installs video cameras in restrooms or publicly reveals employee medical information, or 3. Violation of a specific federal or state law. 2 federal laws which protect the privacy of private employees are the Americans with Disability Act, which prohibits employers from asking certain questions about employees or requiring employees to submit to medical examinations, and the Employee Polygraph Protection Act, which prohibits private employers from requiring or requesting an employee to submit to a polygraph test. Several state laws also grant specific privacy protection to employees. For example, the California State Constitution applies to private sector employees, thus requiring a warrant for most employer searches. A recent example of a state law aimed at protecting employee privacy is Utah's Internet Employment Privacy Protection Act, which was adopted in the 2013 legislative session. This law prohibits an employer from requesting an employee's personal password to a social networking site or otherwise disciplining an employee for refusing to provide such information. Several other states have passed similar legislation. Let's answer a few of the most frequently asked questions about the privacy rights of private sector employees in the context of workplace monitoring. May an employer listen in on phone calls employees make at work? In most instances, the answer is yes. Employers may monitor calls with clients or customers for reasons of quality control or training purposes. However, in some states, like California, the law requires a beep tone to indicate a telephone conversation is being recorded. Federal law allows unannounced monitoring for business-related calls. Of course, the employer's HR policies most likely give the employer the right to monitor all conversations using company-supplied equipment. May an employer read an employee's emails or text messages sent at work? Generally, yes, if the message is sent on a company-owned computer or device or over a company-owned network, particularly where the company has a policy that gives notice of the potential monitoring. The legal impact of employer policies cannot be overstated in this area. For example, the Fourth Circuit recently held that an email a criminal defendant sent to his wife using his employer's email system was properly admitted into evidence against him. The spousal privilege was waived, said the court, because the company had a policy expressly warning that employees have no right of privacy in their use of the employer's computer systems. Similarly, there have been several decisions holding that an otherwise privileged attorney-client communication loses its protected status if sent over an employer system. In the public sector, the U.S. Supreme Court in 2010 unanimously upheld the warrantless search of a police officer's government-owned pager because the search was motivated by legitimate work-related purposes and the officer had no reasonable expectation of privacy in light of the city's equipment use policies. May an employer monitor an employee's computer usage and what the employee accesses on the Internet? Generally, yes, since the employer owns the computer and devices, and most company policies specifically allow such monitoring. However, some union contracts may limit an employer's right to monitor, and several states have enacted so-called off-duty conduct laws, which prohibit an employer from disciplining employees based solely on their personal conduct after hours, even if they use company-provided equipment. In these states, monitoring is not proscribed, but taking adverse against an employee is. May an employee use video monitoring in the workplace? Again, the answer is generally yes. Video monitoring is a commonplace method of deterring theft, maintaining security, and monitoring employee conduct and productivity. However, some states have prohibited video surveillance in certain locations in the workplace, such as restrooms. With regard to employee drug testing, courts have generally upheld such practices against invasion of privacy challenges. Drug testing in the workplace is primarily a state issue, although some federal statutes mandate drug testing of workers in certain professions like airline pilots. Usually, employers may legally administer drug tests under one or more of the following circumstances. 1, where the job requires it or for safety reasons. 2, where the employee has enrolled in a drug rehabilitation program. 3, where the employee was involved in a work-related incident where use of drugs is suspected. Or 4, where management has a reasonable suspicion that a given employee has been using illicit drugs. In summary, although employees do not entirely surrender all of their privacy rights in the workplace, the unique nature of the employer-employee relationship affords employers considerable latitude in monitoring, searching, and testing employees while they are on the job. In terms of location, the workplace is more akin to a school than a home. Next week, we will review the constitutional and other legal protections for medical information.